Hi, I'm Shan Wu with a Undercolor of Law hot take on the newest, maybe the last motion to dismiss, filed in the Manhattan District Attorney's case against Donald Trump, or actually his conviction. The Trump team has filed, I've lost track of how many times they've tried to dismiss it, but they have a new couple of arguments they want to put forth, and I wanted to break it down a little bit for you because it gives us some insights into ongoing issues with Trump's coming Department of Justice, actually. So we'll put up the introduction to their motion to dismiss, and it starts off almost legitimately. It says that they want to move to dismiss under the Presidential Immunity Doctrine, the Presidential Transition Act, and the Supremacy Clause. So in reverse order, I mean, their entire argument rests on the Supremacy Clause because this is a state case. There's nothing to do with Trump's presidency at this point or anything federal. It's all a state case. So they have to use the Supremacy Clause saying there's something wrong here at a federal level because he's going to be the federal executive, and they want to use that as leverage to come into this state case. So that's really the linchpin to everything that they're doing here is going to be the Supremacy Clause. And we've discussed that before, that whatever they come up with, that's really going to be what they're using as their shovel for all this. Now, the Presidential Transition Act seems kind of silly, but their point being that right now he's a very busy guy. He's involved in a transition. You cannot bother him with this sentencing that shouldn't go forward. You cannot bother him with this criminal case he's been convicted of. Well, there's a little bit of factual irony to that, right? Because up until very recently, Trump hasn't participated at all under the Presidential Transition Act. He doesn't want to sign the agreements. He doesn't want his possible nominees to start undergoing their background checks. He's just checked out on it. He's doing it his way. His team wants to do it their way. So that seemed kind of a two-faced argument to make, that you're interfering with our ability to do this transition when actually they're really not taking part in the Presidential Transition Act processes. They're doing their own stuff. Presidential Immunity Doctrine, tough one. They've argued that before. So much of this conduct has nothing to do with his acts as president. We've talked about this before. There's a little sliver of it which they would have to extrapolate, somehow taints the whole thing. The little sliver is some conversations or texts he may have made when he was in the presidency talking about how to handle the matter. But then we get to the really silly part of this where you really see what they're actually up to. And yes, amazingly, they managed to work in the Hunter Biden pardon. So they write that in issuing a 10-year pardon to Hunter Biden that covers any and all crimes, President Biden asserts his son was, quote, selectively unfairly prosecuted, treated differently, talking about how politics led to a miscarriage of justice, which I totally agree with. They then say that these comments amounted to a, quote, extraordinary condemnation of President Biden's own DOJ. They then say this is the same DOJ that coordinated all these terrible supposed witch hunts against President Trump. They're talking about disgraced special counsel Jack Smith, other biased prosecutors on the team. The issue here is I'm not sure why they think Jack Smith is dismissed, disgraced, other than the fact that Trump would dismiss him and that Smith is now given up on trying to do anything with the federal cases. Then they make the point that DA Bragg, this is the real point, has engaged in, quote, precisely the type of political theater that President Biden condemned. And they want to argue that the case is based on contrived, defective, unprecedented legal theories. Unprecedented legal theory is an okay argument to make because that's a legal theory. So here is the problem here. This is an argument by analogy. They want to make this analogy that Hunter Biden's pardon is somehow analogous to something that's gone wrong here. It's not only a weak one, but doesn't make any sense. In law, you argue by analogy and persuasion all the time. You say, this case doesn't look like the same set of facts, but there's an underlying theme that relates to my case. Let me tell you about that, Judge. So that's totally lacking here. This is not a federal case. I mean, where is the legal analysis? Their argument seems to go, President Joe Biden did not like what the Department of Justice was doing and pardoned his son. Therefore, what? The governor of New York should pardon Donald Trump because that would be the equivalent of an executive, the governor in New York, the state executive, exercising a pardon power. But of course, the governor would have to think that the case is one that's correct for pardoning, that something was done wrong. So the problem here is why this is so misplaced, really. As we've discussed, the pardon power has nothing to do with legal analysis. It's just a raw power that the executive has to pardon someone, grant them mercy whenever they think they deserve mercy. So you can't really use it as a legal basis for a motion to dismiss, which really has to be based on a legal argument. His lawyers know that. These arguments would be frivolous arguments, but for two things. Their client is the next president of the United States, so most courts, including the U.S. Supreme Court, are going to be afraid to call them out as this is nonsense arguments. And number two, these two personal lawyers for Trump will likely be high-ranking DOJ officials. Todd Blanche was named by Trump to be the number 2 at DOJ, the Deputy Attorney General. And Emil Bove is going to be his right-hand man, the Principal Deputy Attorney General, respectively in DOJ acronyms, the DAG and the PAYDAG. And so I strongly suspect, you may too, that they're going to bring DOJ's full weight to bear in support of their own arguments made in this state case on behalf of their client, Donald Trump. Now, who knows? Maybe they'll actually make the arguments on behalf of DOJ without recusing themselves because there's no rules anymore. Actually, this might be a good time for Attorney General Merrick Garland and the existing Office of Legal Counsel to maybe address this proactively, that given the unlikely event that this is that could ever reoccur again, they ought to address it, which is, this is the first time in history that top DOJ officials were the criminal defense lawyers for a sitting president. They ought to address this fact and say, hey, those folks cannot take part in anything to do with those cases. They can't weigh in on the state cases. They can't talk about anything to do on the federal cases, including any cases that could be tried against co-defendants of the presidents. For example, in the documents case, the case may still be alive with regard to the two co-defendants. They can't weigh in on anything to do with Georgia and Manhattan, certainly. They're the lawyers there. So it would be a good idea to proactively actually say something about that, even though it's never come up before, for precisely that reason. It hasn't come up before. Now, there are genuine legal arguments that have been raised here under the motion to dismiss. They've been saying for a long time they think that Jack Smith's investigation was unconstitutional, and the lawyers are trying very hard to turn all their sort of misplaced factual arguments in the Manhattan case into constitutional arguments because they know that that's where it's got to go. That's the only chance they really have. The trial judge is not there to make constitutional pronouncements. What should Judge Merchan do? He should just sentence Trump. If there's going to be a brand spanking new constitutional argument that says you cannot sentence a soon-to-be president, then he doesn't need to make that decision. Just sentence the man. And then let higher courts, let the Supreme Court that does the constitutional stuff, let them reverse him. I mean, what's the worst that can happen? He sentences him and then the high court throws it out. He doesn't have to be so bollocksed up by all of these constitutional issues that are, of course, ones of first impression. He should just sentence him. Another example, I have to just point this out, of a glaringly lousy argument. Let's take a look at their table of contents. You don't have to read through the whole thing, but you can just look at the table of contents, because really long legal briefs actually have table of contents. Look at this particular item. We'll put it up for you. Stormy Daniels is a liar. That's their table of contents point. Right. Now, what's wrong with that? They're free to call her that at trial. They can cross-examine her. But this is a motion to dismiss. That's a jury question, and the jury already disagreed with them about that. They can argue prosecutorial misconduct, the prosecutors did something wrong with the scope of her testimony. That's all fine to argue on appeal, but arguing she's a liar is totally pointless. Now, I'm going to play you a little clip from Fox News, and this is the discussion that goes back to why is the Hunter Biden pardon at all relevant. So we'll take a listen to that.
And Democrats question why Joe Biden would criticize his own Department of Justice rather than just saying, look, I am a father and my son has had problems and he is now on the straight and narrow. So I am going to grant him a pardon. Democrats would have been okay with that. But just the fact that he blew up the Department of Justice, his own Department of Justice, and everybody in the Department of Justice who we've seen so far.
So let's answer the question of, did Biden throw his own DOJ under the bus? No, not really. Did he disagree with what they did? Damn right he did. That's why he issued the pardon. But any pardon goes against what the DOJ once did, maybe in this administration, maybe in earlier, much earlier ones. Any pardon. What he did was, first of all, questionable as to whether it's really his own DOJ. It is Garland overseeing it, but it was a separate special counsel that was appointed to pursue Hunter all this time. But the point is, there is no point to say, oh, this is a pardon. He's completely tanked his own DOJ. Again, any pardon is going to say there's something wrong with the result here. It's not saying DOJ is corrupt. It's not saying all the evidence was improper. Just saying, in my judgment as the executive, there's something wrong here that deserves a pardon. Oh, by the way, there's also a new motion to dismiss in the Georgia case, which does make the constitutional argument, but their constitutional argument is you just can't prosecute a sitting president, similar to Manhattan. But I'm quite surprised. Hunter Biden's not mentioned in that. What's up? So that's it for now. Thank you again for all the replies and the comments. They're really useful and very heartwarming to see. It really gives me some stuff to think about in terms of what to talk with you about in the future. So take care.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.